Okay, so we'll get started, and then if other people join, they could, kind of we'll catch them up. So my name is Deirdre Baker. I am one of the attorneys with the McCoskey Law Group. We're located in Garden City, and we're elder law attorneys. So our practice focuses primarily in the areas of estate planning, trust and estates, probate proceedings, asset protection, guardianships, and Medicaid planning and Medicaid applications. So tonight, we'll be discussing, an elder law workshop, which basically covers various topics. And when we're talking about elder law, we're really talking about four general categories. And that's how we describe it in our office anyway. But basically, we call them the four questions. So who will make healthcare decisions for me if I am unable to? Who will make financial decisions for me if I am unable to? And how will I pay for long-term care? And how do I leave assets to my heirs? So we're going to talk about all of these topics in the next hour or so. And I also had emailed over some information and some handouts. So if you didn't get them, just let me know. I'm happy to resend the email. Um, Two of them we're going to be discussing tonight in detail, and then the other handouts are really just more information for your own purposes and just if you wanted to take some notes on them. So let's get started.
On this or on the?
Okay. So like I just said, these are the four questions that I just went over. When we're talking about elder law, these are the four general areas that an elder law issue typically falls into one or more of these four categories. So we're going to start with surrogate healthcare decision making. So surrogate healthcare decision making basically means a third party making a medical decision on behalf of somebody else. So on your screen here are all the different ways that those decisions can take place. And it could be using one of these documents, or it could be using a combination of them. And we're going to talk about all of these in a bit more detail. So the first document is a healthcare proxy, and this is actually one of the documents that I included in the email earlier today. So you should have gotten something that looks like this. It's a 2-page document, and we included it the way we did so that if you don't already have a healthcare proxy, you can go ahead and actually execute this document as soon as you have witnesses available. So basically, what is a healthcare proxy? It's a document where the principal, the person creating the document, appoints at least one person to act as their primary agent, and there's also the option for them to appoint a successor or a backup agent. And a healthcare proxy is a document that goes into effect when a doctor has determined that the principal is unable to make his or her wishes known with regard to their medical care. So long as the principal or an individual is able to speak, write, nod, blink, or in some way communicate with their medical staff what they want or don't want regarding their medical treatment, what that person wants will trump whatever the agent says. If a person can't speak or they can't in any way communicate with their doctor, that's when the healthcare proxy will go into effect. And if you see here on the actual form, what you'll basically do is you put your name on the first line, and it says hereby appoint, and you'll list the name and the address and the telephone number of whomever you want to choose to act in that role. If that person's unavailable, you also have the option, but you don't have to, appoint a successor agent. And again, you also put in their name, address, and telephone number. The document should be signed by you, and it has to be signed in front of two disinterested witnesses. And that basically means two people that aren't named in the document themselves. So some things to consider when appointing someone as a healthcare proxy or an agent under your healthcare proxy is you want to pick someone that ideally, obviously, you know and you trust, but someone who ideally is going to be available. So if you have children, but your children live in Alaska, it may not be a good idea to name them as your healthcare agent. You want someone who's going to be available, someone who's going to be able to communicate with your doctors, ideally someone who'd be able to be at your bedside if a decision needed to be made. And if you have multiple children, I know sometimes it gets tough because you want everyone to feel included, but being someone's healthcare agent can be a difficult job. It's emotional. You're making sometimes difficult decisions. So you want to make sure that you're appointing someone that you not only trust, but someone that you think can emotionally handle the job of making difficult decisions on your behalf. The healthcare proxy, unless you revoke it, typically stays in effect for the remainder of your life. One of the nice things about the healthcare proxy is that it's one of the few legal documents where a copy is just as good as an original. So you can execute the document that was emailed to you. You can make a copy for your doctor, your specialists. You can give copies to your agents. And that way you just, we often recommend that you make a copy and fold it up and keep it with your insurance cards. So if God forbid you end up in the hospital and you can't communicate, at least the medical staff will know who to contact. The document also typically includes language that you see on your screen here, which says that my agent and my successor agent know my wishes in regard to artificial nutrition and hydration. So this language here is meant to serve as proof or a cue to a doctor or someone on a medical staff reviewing the form that your agents have actual knowledge about what you want and don't want with regard to your medical treatment. If you put every single thing you may want or don't want in the healthcare proxy, it wouldn't be 2 pages, it would be a 30-page document. So instead, rather than bogging down the document with a lot of very particular instructions or limitations, language like this is often preferable because it gives your agents a little more flexibility, and it gives your agents the ability to make decisions in a variety of circumstances. So often a companion document to a healthcare proxy is something called a living will. Not to be confused with your last will and testament. That's something that we'll discuss a little bit later on. But a living will is a document where you're not appointing anyone to act on your behalf. Instead, the document serves almost as a set of instructions for both your agent and some medical personnel who's reviewing the form. And a living will attempts to anticipate possible future medical circumstances. And it essentially lists or describes what your preferences are with regard to those particular medical treatments or procedures. Very often our office does not prepare these documents unless a client has very particular wants or preferences. The reason that we often do not prepare a living will is we feel it's really nearly impossible to anticipate every possible future medical circumstance that someone may encounter during their life. So instead, we encourage clients to speak with their healthcare agents, especially as circumstances or preferences change. So rather than constantly updating their living will, they're updating their agent, the person who has a brain and a heart who's going to be standing there with the doctor making these decisions when these circumstances arise. Another document that discusses medical treatment is something called a MOLST form, which stands for Medical Orders for Life-Sustaining Treatment. So this is a form that you wouldn't go to an attorney to have prepared. This is something that's typically done in a hospital setting. So you can't miss them. They're bright pink forms. And it's something that usually will be initiated by either a nurse or a doctor or a nurse practitioner, some medical professional, generally done when there may be an expectation that the patient does not have long to live. And in this document, which is meant to travel with that person from facility to facility if they end up getting transferred around, and it's meant for the patient or the individual to kind of put in one central place different treatments that they want, typically focusing on end-of-life treatment. So in the absence of a healthcare proxy and in the absence of a living will or any set of instructions for medical decision-making, New York State and other states have similar laws, but New York State has something called the Family Healthcare Decisions Act. So this statute applies to individuals who are in some type of medical facility, whether it's a hospital or a skilled nursing facility, and that individual doesn't have a healthcare proxy, and they find themselves unable to communicate with the doctor and make their medical wishes known. So the doctors need to know who to communicate with in order to, perform a surgery, administer medication. So that's when, in the absence of a healthcare proxy, they will look to the Family Healthcare Decisions Act. So the Family Healthcare Decisions Act essentially creates a list of individuals who can make decisions on behalf of somebody else. And the list really focuses heavily on your blood relationships with other individuals. So the first person on the list would be a court-appointed guardian. If you don't have a court-appointed guardian, it then asks if the individual has a spouse. If they don't have a spouse, do they have children? If they don't have children, are their parents alive? If their parents are not alive, do they have siblings? And it kind of goes down the line to more remote family members. So on the one hand, this is a really nice safety net for individuals who don't have a plan in place and they find themselves unexpectedly incapacitated in a hospital. But as you can imagine, because it focuses solely on blood relationships, it's maybe not reflective of who you want making decisions on your behalf. So for example, if you're unmarried and you have children, but maybe you're estranged from one of your children, this act doesn't really take that into account. If you have a niece who's a nurse and you really would have a strong preference for her to act as your healthcare agent because you know she would do what you wanted her to do, if she's behind someone who has a higher priority, that could be an issue. You could also imagine if there's more than one person in a class who are eligible to make decisions. For example, if you have 3 adult children and all 3 of them are yelling different instructions at the doctor, that can also create an issue. It could also maybe delay emergency treatment. So rather than relying on the Family Healthcare Decisions Act, if you don't already have one, everyone now has a healthcare proxy, so you can, pick at least one person, if not more, that you trust. Let them know that you're intending on appointing them as your agent. Have a conversation with them so that if, God forbid, they needed to act, they're prepared. And then again, make a bunch of copies, give them to the appropriate doctors and individuals, and that way you at least know that that's done, and gives you a little peace of mind. Something that many people I'm sure have heard of is a do not resuscitate order, or a DNR. So New York State and many other states have a presumption for resuscitation, which basically means that doctors are obligated to do everything necessary to bring somebody back if they are unconscious or incapacitated. So someone could be 98 years old. If they are unresponsive, the doctors are ethically and legally required to take even extraordinary means to bring this person back. And that may not be what that person wants. It could, be aggressive. It could be painful. And having a healthcare proxy alone can't overcome this presumption that someone would want to be resuscitated. And that's where a DNR comes in. A DNR is a document where, again, would be generally prepared by someone in a hospital or some medical facility. And it's a document that almost gives the medical staff a pass for not taking affirmative action to bring somebody back or to save their life. So this is typically not something that you do well in advance. It's something that's generally done if someone has a terminal illness, or if someone has various health issues, or they're a little bit older. Just a document to be aware of. And that's basically it for the surrogate healthcare decision making. So as I go through, there's both a chat function, and because we're a small group tonight, if anyone has a question, please feel free to either email me later on or just to interrupt me and ask, because I want everyone to get as much information out of this as they want or need to. So now we're covering the second question under the topic of elder law, and it's who's going to make my financial decisions if I'm unable to. And you'll see the 3 little subtopics we're going to be covering under this heading are powers of attorney, revocable trusts, and guardianships. So out of all of the legal documents that clients come to attorneys to have prepared, I often say that I think the power of attorney is probably the most important document that an individual can have. Because with the properly done power of attorney, you can do a lot of other planning on someone's behalf if they become unable to do that themselves. And I also provided a sample of the power of attorney. So unlike the healthcare proxy, this isn't something that I sent you to execute yourself. And the main reason for that is it's a complicated document, And it's really something that you should only execute after speaking with someone who's familiar with them, so that they can tell you, all the consequences of the various choices, and really to make sure that it's done properly. It's a document that we often see clients bringing into us. They've gone somewhere else, they've printed something off the internet, and they think that they have a power of attorney, and they come to us when they really need to use it, only to find out that it wasn't done properly, or it doesn't give them sufficient authority to do whatever they're trying to do. So basically, a power of attorney is a document where, like the healthcare proxy, you're appointing at least one person to make financial decisions on your behalf. And there's you turn to the sample that I gave you on page 3 of the document. There's a list of jobs that are included. And this statutory form that was sent out is a document that was created by New York State. So in order to have a valid statutory form, the form that you use must mirror what New York State created. So you can't delete things that you don't want in there, or you don't apply to you. If there's a particular provision that you don't want included, you simply don't initial or sign that particular provision. One thing to keep in mind, however, is that although you can't delete or take things away from the form, you can add modifications to it. And over the years, our office, after meeting with various clients in different scenarios, have slowly added modifications to our document over the years, to make it a really robust document, and to make it really clear to someone who's reviewing it what that agent is authorized to do. For example, we've included a lot of Medicaid planning powers in our document. So if the principal who created the form later needs some type of long-term care, his or her agent has the authority to protect their assets and get them onto the Medicaid program. So if the specific power isn't authorized in the document, then the agent can't perform that particular task. So again, on page 2 and 3 of your handout, and you see that list of tasks for letters A through O. If there's a particular power that's not initialed, or if the agent has an initial next to letter P allowing you to do all of those tasks, then the agent won't be able to handle that particular transaction if they don't have the authority. So essentially, the power of attorney can be a very narrow document authorizing only limited authority or limited tasks, or it could be really broad. And what document you should prepare really depends on your specific goals and your specific family dynamics and your circumstances. So it's really something that, again, should be done after you've had a conversation with someone who's familiar with these types of documents. One main difference between the healthcare proxy and the power of attorney, again, not just because one deals with medical information and one deals with financial, but really the main difference is, unlike the healthcare proxy, which only goes into effect when the person is incapacitated, the durable power of attorney that we often execute for clients goes into effect as soon as the principal and the agent signs it. So it's critically important that the person you appoint as your agent is someone that you trust, because they're going to have the authority to act right away. So if there's someone that you don't think is really great at managing money, or you don't think will be upfront with you, it's not someone that you should be including on this type of document, because they're going to have a lot of authority. So who are the players, or who are the parties involved when it comes to a power of attorney? So like I've just mentioned, the principal is the person who is creating the document, and they're the one who is granting the authority for someone else to make financial decisions for them. And the agent is the person that you're giving that authority to. It could be a spouse, it could be a child, it could be a family friend, it could be another relative. The important thing is that it's someone that you have a trusted relationship with. So the sample that I sent you is a very bare bones copy of the statutory form. So the current form was signed into law back in 2009, and then it was revised in September of 2010. And if you flip through it, you'll see it's a complicated document. There's a lot of places to initial or not initial and sign. And there's a second part of the form, which is called the gifts rider, which is often signed at the same time as the statutory form you're looking at. This has to be notarized. It has to be signed in front of 2 witnesses. So a lot of the criticism of this particular form is that it's too complicated, it's too difficult for people to understand. So in light of that, there was actually a big push for the New York State Legislature to amend the form and create a more simplified version of it. And that law has actually been passed. So we're actually now just waiting for the legislature to actually put that into effect. And we're hoping that being a simplified, more streamlined version of the form, that more people will be encouraged to execute these documents, because it really does save a lot of headaches down the road if you need assistance. In addition to powers of attorney, another way that you can appoint or allow someone to make financial decisions on your behalf is by creating and funding a revocable trust. So revocable trust is basically it's a document that you create during your life, and you also fund it during your life. And the trust, similar to a last will and testament, sets out rules or instructions for how the assets owned by the trust will be distributed at your passing. So these are the parties that are involved in the revocable trust. The settlor is the person who's creating the trust. They're the person who determines the rules and they set the terms. The trustee is the person who is appointed to manage the trust property on behalf of the settlor. And with a revocable trust, very often the settlor and the trustee are the same person. So I create a revocable trust, I name myself as my own trustee, and I retain a lot of control over my assets. And then the third category of individuals involved are the beneficiaries of the trust. You know, who's going to get stuff when the trust is terminated because I've passed away. So one thing that is really, really important, and it can't be emphasized enough, creating the trust itself is really only the first step. It's really only half the battle. If your trust isn't funded, meaning your trust doesn't own anything, you don't ever retitle anything in the name of your trust, then your trust really serves no legal purpose, because the trust is only as good as the things that you put into it. So on your screen there are some common examples of assets that are typically used to fund a revocable trust. So something like your house, whether it's your primary residence or maybe a vacation home or rental property that you have, your bank accounts, could be your everyday checking account, you know, all the way through investment accounts that you have, and brokerage accounts. And the benefit, although it's time consuming because it's more steps to do the deed and retitle bank accounts, the benefit of doing this is all of your assets are consolidated in one place. And if you can't act, you have the ability to name a backup or successor trustee who can step in and manage all of these assets on your behalf if you're alive, but unable to really take care of these things. Let me go back for 1 second. So again, if one of the other main benefits of doing the revocable trust is not only does it provide for asset management during your lifetime, if you're unable to manage those things, at your passing, all of the assets that are titled in the name of the trust avoid probate, meaning that at your death, your intended beneficiaries automatically have the ability to access the accounts for final expenses. If they needed to, they could sell the house right away without waiting on the courts to give them the authority to do that. And this is just something that we've been seeing for the past year or so with the COVID-19 pandemic. The courts on a good day can be really slow and difficult to deal with. And now we've just seen the effect that months of delays and backlog can add. And even relatively straightforward probate proceedings can really be delayed by several months just because of the sheer volume of cases that the surrogates courts often have to deal with. So guardianship. So a guardianship is really the last resort. If you don't have either a healthcare proxy or a power of attorney, if there's no plan in place and you have assets that are in your name alone, or you have no one that's able to make decisions on your behalf, very often someone in your life is now looking at a guardianship to handle some aspect of your life. So if you find yourself in this situation, or if a loved one finds themselves in a situation unable to deal with you, you're looking at a guardianship proceeding. And a guardianship proceeding is essentially a court proceeding where someone, whether it's an individual or a hospital or an organization, petitions the court where the person lives and asks the court for permission to act on that individual's behalf. So, like a power of attorney, a guardianship can be very narrow. You know, someone only needs assistance with a particular task or a few things in their life, or the guardianship can be really broad, and the petitioner can be telling the court that this individual is completely incapacitated and they cannot manage their finances, they can't pay their bills, they can't determine who's going to provide care to them, they can't communicate with their doctors. So it can be a really broad, almost overreaching resolution to someone's incapacity. One thing I'll note is a guardianship is really something that should only be pursued as a last resort. And that's why we often really try to encourage clients to have these advanced directives, these powers of attorney, and these healthcare proxies in place to avoid something like this, for the reasons that you see on your screen. So some of the issues with a guardianship is it's expensive. You're dealing with a court proceeding, which means you're hiring at least one attorney who's going to prepare the documents and file them. There's filing fees. It's public record. So under the statute, certain family members are entitled to be notified that someone is seeking guardianship on your behalf. It involves these individuals being put on notice that you may lack capacity, and you may be also may involve family members that, although you have a blood relationship with, you may be estranged from. And even though you don't have an actual relationship with them, under the law, they're entitled to be notified and they can show up and participate in this hearing, which may not be what you want. As someone who handles lots of guardianships, they could be lengthy. It's not really a simplified process, especially now with COVID. There's really not a lot of in-person hearings going on. So things are done over Zoom. It makes it more difficult. And in addition to notifying people that you may not want notified, your personal information is now part of the court record. It's public record. So your finances, the type of insurance you have, some of your, history, or essentially the petitioner has to document why you need a guardian. And that involves, illustrating to the court things that you can't handle on your own for various reasons. But most concerning of all, I think, is that even if someone you trust and love is the one petitioning the court out of necessity, at the end of the day, it's really the judge in the court that has the final say-so for whether a guardian is necessary. And if a guardian is necessary, who's the most appropriate person to act in that role? And it may not be the person who's petitioning. The court may determine that your daughter or your niece or your spouse isn't the best person for various reasons, and that some organization or some lawyer who you don't know is the best person. And now someone you've never met and who's only obligated under the statute to meet with you between 4 and 12 times a year can have a lot of authority over your life. They can communicate with your doctors, they can pay your bills, they marshal or collect all of your assets. And I don't say this to scare you, I just say this to give you the reality of it. And this is something that can easily be avoided with just doing very, very simple planning. So that is the end of the surrogate decision making. So we covered the healthcare and the financial surrogate decision making. So now the third question, or the third topic for elder law, is long-term care. What is long-term care? If I need long-term care, how am I going to pay for it? And then we're going to talk a little bit about some of the different Medicaid programs that there are and what the eligibility rules are, and how you can become eligible for it should you need that type of coverage. So what is long-term care? Long-term care, very basically, is really when someone requires assistance in some capacity with their activities of daily living. So on your screen, you'll see some common examples of activities of daily living. If someone, whether temporarily or on a permanent basis, can't handle certain aspects of their life safely, then more often than not, this is an individual who is likely in need of some type of long-term care. So if someone's able to, if they can't get out of bed safely, if they need help getting in and out of chairs, getting dressed, basically all the things that an individual does throughout his or her day, if you can't do that safely, then you're really at risk of a fall, not being medicated properly, not getting to the doctor the way you should. So this is basically what I'm referring to when I talk about long-term care. So how do I pay for long-term care is generally the most common question, because as you can imagine, a lot of this care is expensive, especially if it's done on a long-term basis. So on your screen are the basic ways that I'm aware of to pay for long-term care. So obviously this doesn't cover if you have a family member that's providing the care to you for free because they're a family member. If you don't have someone who's able or willing to do that, then you're looking at one of these ways to pay for the care. Either private pay, which for a lot of people isn't an option because it's expensive. Long-term care insurance, which if you have it, great. It's always a good idea to take a look and review the policy and see what the terms are. And some helpful things to look at when you're reviewing your long-term care insurance policy, if you have it, are what's the elimination period? The elimination period is typically the length of time between submitting your claim and when the insurance company will actually start paying for your coverage. So it's a good thing to know, because if your elimination period is 90 days, that means for 90 days, the insurance company isn't paying for your care. So you need to have some other way to make sure that care is being paid for. Otherwise, you're not going to have it. Other things to consider when you're looking at your long-term care insurance policy is it a lifetime benefit of a length of time or an amount of money? So sometimes you'll see the policy will pay out for 3 years, and once 3 years is expired, that's it, no more coverage. Or it may be something where you have a certain amount of money that you're allowed to spend. It could be 100, 200, whatever the terms of your policy say. And then from there, it will break down how that coverage gets paid out. So often it will be, if you're in a facility, they'll pay you a certain amount of money per day. If you're at home, they'll pay a certain amount of money per day. So if you have long-term care insurance, or you're thinking about getting it, these are some things that you should be aware of and just considering, because you want to make sure that you have a plan in place to fill in any potential gaps in coverage. Medicare pays for very limited long-term care. The most common example of Medicare covered long-term care is when someone's discharged from a rehab or a hospital. Medicare will pay for limited physical and occupational therapy at home, and it typically lasts for about 4 to 6 weeks, and it's a few hours a day. So this is a nice benefit, but if someone needs coverage on an ongoing basis, Medicare really isn't the program that's going to fulfill that need. If you or your spouse were a veteran, or are a veteran rather, you may be entitled to some home care coverage through the Veterans Administration. Very often these programs, however, have some type of financial component, meaning it's a means tested program. So just because someone's a veteran, it's not guaranteed that they're going to get some home care coverage. You generally have to qualify in terms of both income and asset restrictions. And there's also even restrictions on what veterans are eligible. So if you were a veteran that, never served during an active period of war, then you may not be eligible for coverage at all. So if you were a loved one, think you may be entitled to veterans benefits and you're someone who's in need of care, it's not a bad thing to pursue. And generally the representative at the VA are usually really helpful in walking you through what your possible eligibility for different programs are. And then finally is the Medicaid program, which I know a lot of people have heard about and is often confused with the Medicare program. So one way that I like to describe the difference between Medicare and Medicaid is that Medicare is something that you will get by virtue of being over the age of 65 or because you've become disabled. Medicaid is something that you qualify for because of your financial resources. So as an example, someone like Bill Gates, who has a lot of money, he'll always qualify for Medicare if he's over the age of 65, but he's never going to get Medicaid. So that might be a helpful way to think about it. It's really a question of age and your financial resources. So we're lucky here in New York State in some ways regarding Medicaid, primarily because although it's not perfect and there's a lot of drawbacks to the Medicaid program, here in New York State, it's a fairly generous and robust program. And the two programs you see on your screen are the most common Medicaid programs that our office helps clients obtain coverage or eligibility for. So before we get into the details of them, one thing I want to note is the Community Medicaid program, for those of you who haven't heard, recently underwent some significant changes. So last year, when New York State passed its annual budget, as they do every year, there were threatened Medicaid cuts. And last year, they finally made good on those threats. So the Community Medicaid program was in particular affected by these changes. And there are going to be there's going to be a look back period imposed for community Medicaid, as well as nursing home benefits. So these changes for the Community Medicaid program were initially supposed to go into effect in October of 2020. It was then pushed back to January of this year. It was then pushed back to April 1st. And we haven't seen anything definitive, but it looks like it's going to be pushed back until at the earliest sometime this summer, but we're waiting on more clarification. So we're going to talk a little bit in more detail about both of these programs. So the eligibility for Medicaid, these apply whether or not these apply whether or not you're in the community, you're at home, or if you're in a nursing home. And I apologize, that resource allowance should say $15,900 in assets. The asset limitation increased a bit in January. And not all resources are counted against that allowance that you're allowed to have. So if you look down there, there's some exempt assets. So if you have a prepaid funeral, your primary residence, if you have retirement accounts like 401ks and IRAs, those assets are not counted as part of the $15,900 you're currently allowed to have in your name. So the house exemption. So this is something that really applies to a lot of people. A lot of people own their home, and even though they own their home, they don't have enough cash to pay for long-term care on an ongoing basis because it gets really expensive. So Medicaid doesn't penalize you for owning your home. They don't count the equity or the value of your home as available to you, which is a great thing for a lot of people. But in order for the house to truly be considered as exempt or kind of off the table for Medicaid purposes, is either the Medicaid recipient or his or her spouse live in the house. Without this, Medicaid reserves the right to place a lien on the home in order to kind of get some of the money back that they've paid for your care. There's also some ways that you can you could transfer or get the house out of your name without penalty. If you have a sibling who lives in the house with you, he or she could you could transfer your interest in the home to them. And if there becomes a scenario where the house is no longer considered exempt, Medicaid then reserves the right, like I said, to place a lien on the home, which is why before we are submitting a Medicaid application, we're often looking for ways to get the house out of that individual's name or to protect it in some way without affecting their Medicaid eligibility. So we'll talk about retirement plans in the Medicaid context. So very often, families that we meet with, the potential Medicaid applicant has a retirement account. So the retirement account doesn't have to be a 401k or an IRA. Sometimes it's a retirement annuity, a retirement CD. Essentially, it's any asset that has grown tax deferred. And that's part of the reason why Medicaid doesn't consider it as available to the applicant. The applicant gets taxed on the money as they take distributions from the account. And that's why Medicaid doesn't treat it the same way as they treat money in your checking or savings account. Because Medicaid's aware that if you take a large distribution from that account, you're going to have to pay a lot of income tax on it. So all Medicaid does is the required minimum distributions that you take from that account on a monthly or annual basis is treated as part of your income. But the remaining balance or principal in that account is not counted as part of that $15,900 you're allowed to have in your name. So limits on income. So in addition to looking at money in your bank account, if you are in the community, Medicaid also imposes income limitations. So again, I'm sorry, this instead of 859, this should say 904. So if you are living in the community and you're looking to get some help at home and you're pursuing home care Medicaid benefits, you're allowed to have $904 per month in income. And they also give you a credit or a deduction, anything that you spend out of pocket on your health insurance premiums. If you have income over and above that, which most people do, there are ways to shelter or protect that income. And Medicaid gives you a couple of options. If you have income of, $2,000 a month, Medicaid is going to disregard about $1,000 a month. So with that remaining $1,000 that you have, they treat that money almost like a monthly deductible. And they say, before we pay for your home care, you have to demonstrate to us that you've met this deductible in some way. And the three basic ways of doing that is sending that money into Medicaid every month. But most people don't want to do that because they have taxes and insurance and other expenses. So that's not always so attractive. If you have a lot of out-of-pocket medical expenses, like prescriptions or therapies or supplies, and those expenses are more than your surplus income, if you submit proof of that to Medicaid, then they'll pay for your home care. Again, not a very common option for clients because most people, thankfully, have good health insurance and it pays for a lot of their medical expenses. So the most common option for a lot of individuals is establishing something called a pooled income trust, which is basically a separate bank account that is established for the Medicaid applicant, and his or her income gets deposited there on a monthly basis. And from there, it's available for them to pay their bills, to pay things like utilities, credit card bill, property taxes, mortgage, rent. So again, this is a decision that's made based on the person's income and their particular circumstances, but it's a nice option for a lot of clients to be able to protect their income. And the main difference with how income is treated, whether you're in the community or if you're in a facility, is when you're in a nursing home, unfortunately, there's no way to shelter or protect this income. And Medicaid only gives you a $50, what they call a personal needs allowance. And all of your other income is due to the facility, and Medicaid will pay the remainder of your bill. And the main reason for this is Medicaid's position is if you're living as a permanent resident in a nursing home, you don't need to you don't need to pay your other bills. All of your basic needs are being met at the facility. So we're not going to give you an allowance to pay for utilities and cable because you're living in the nursing home now. So community spouse. So if an individual who's applying for services is married, the non-applying spouse is referred to often as the community spouse. So Medicaid has rules in place so that this community spouse isn't left with nothing. They want to make sure that this person is able to keep some assets in case they need their own care or just to be able to pay their bills and meet their expenses. They also want to make sure that if there's two people living in a home and one of them ends up in a facility, if the sick spouse's income is all going to the nursing home and the well spouse in the community has very little income, Medicaid recognizes that they may have difficulty paying for and maintaining their home and their other expenses. So the figure you see on the screen, the income amount of $3,160, that's to ensure that the community spouse has at least that amount of monthly income so that they have sufficient income to, again, maintain themselves in the community. So if you're not eligible for services, but you need care, there's basically, two ways to become eligible for services. You can either spend down your resources, which basically means pay for your own care out of pocket until your assets dip below the $15,900 allowance, or you can make transfers. So whether or not making transfers is an option to you really depends on your family circumstances, and it really is also very contingent on the type of coverage that you are looking for. So for example, even though Medicaid is eventually going to be imposing a 2.5-year look back for community-based coverage, right now, individuals who apply are still assessed under the current regulations. So until the new rules go into effect, there is no look back period for home care. So if an individual were to make transfers today, March 22nd, if all of their assets were below the $15,900 allowance by the end of the month, they would be financially eligible to apply as of April 1st. So again, Medicaid is a very nuanced program. There's a lot of different moving parts. So if you or someone you know may be in need of care, it's not a bad idea to kind of talk to someone and pursue potential eligibility, or at least find out what your options are. So the look back period. I know very often, people have heard of the 5-year look back period for nursing home care. Basically what the look back period means, or what it refers to, is if you are looking for nursing home coverage as of April 1st, 2021, the 5-year look back period means you must disclose or provide Medicaid with your financial assets dating back to April 1st, 2016. Even if the accounts have since been closed, even if there's other people on the account with you, you have to give Medicaid every page of every statement, the tax returns, and the caseworker performs an audit of all those financial records. And really what Medicaid is looking for is, did this individual get rid of or gift or transfer money during the 5-year look back period for the purposes of qualifying for Medicaid? So Medicaid is looking for what they consider problematic transfers. And what they'll do is they'll go through and they'll highlight or make note of what they consider large transactions. So the rule of thumb in our office when we're preparing a Medicaid application is we're looking for explanations for transfers of $2,000 or more. So certain transactions they're easy. If you get a monthly deposit from Social Security of $2,100, that makes sense. Medicaid's not going to question that because your bank statement reflects that that's your income. If you have a canceled check to your dentist for $5,000 for dental work, that's okay because that's something that directly benefits you. What Medicaid, on the other hand, is concerned about is if there are cash withdrawals, or if there are transfers to your kids, or some other transfer that doesn't really benefit you in some way. That's where Medicaid kind of starts highlighting things and putting them off to the side. And the potential consequences of these transactions is Medicaid may impose something called a penalty period for you. So this is the very basic explanation for what a penalty period is and how it is assessed. So this is really in the nursing home context, because although there's going to be a penalty period for home care in the future, full disclosure, we don't really have a lot of clarity about what these calculations are going to look like, how Medicaid is going to assess these penalties. So for now, for the purposes of explaining the penalty period, we'll do it in the context of nursing home care. So the number on top, the value of the asset transferred, that number is really the whatever resulting figure the Medicaid caseworker gets after adding up all those problematic transfers that he or she found while they reviewed your 5 years of financial information. And then they take that number and they divide it by the average cost of a nursing home in the county where you're applying. So one thing to note is the number that Medicaid uses is often different than the actual cost of the nursing home care. And the reason they do that is Medicaid uses a lower number because it results in a longer penalty period. So as an example, if your financial audit by the Medicaid caseworker came up with $30,000 worth of gifts or transfers that you couldn't explain, or they didn't buy your explanation, for Nassau County, they would take that $30,000, they would divide it by the average cost of the nursing home in Nassau County, and the resulting figure would be 2.2 months. So for 2.2 months, you would be responsible for paying for your own nursing home care out of pocket. And again, the nursing home doesn't really cost $13,407. It really costs something more in the ballpark of $15,000. So, 2.2 months times $15,000 is a significant amount of money. So that's something just to keep in mind when it comes to things like making gifts, or that's not to scare you from making, Christmas gifts to your grandkids or wedding gifts to your relatives and loved ones. But when it comes to large sums of money, it's just something to be aware of. So some ways you can transfer money out of your name right now without incurring a Medicaid penalty. So as I mentioned before, right now, the look back period for community Medicaid hasn't started yet. And one really helpful or beneficial transfer exemption that we have, regardless of whether you're in a nursing home or at home, is Medicaid does not penalize you for making transfers to your spouse. So if I'm married and I'm in need of some home care and I have too much money in my name, I have more than $15,900 in my name, it doesn't mean I have to spend all that money down, excuse me, and then apply for services. Because I'm married, I could take that money that's over and above $15,900, I could transfer it to my spouse, and the first day of the following month, I will be financially eligible to apply for either community or nursing home coverage, depending on what my needs were. So for a lot of people, this makes getting the first spouse at least eligible for Medicaid, relatively quickly. And then we touched upon it a little bit before, but there are certain transfer exemptions for your house that exist. So you can transfer it to your spouse because that's included in the spousal transfer. You can transfer it to a child that is designated as a caretaker child. And a caretaker child is basically an adult child that has lived with you for at least 2 years before you submit your Medicaid application. And the reason Medicaid allows for this transfer is Medicaid basically assumes that if this child wasn't helping take care of you, you probably would have needed to seek Medicaid coverage sooner. So because of that, they give you this option to transfer the house to this child. Transfers to certain types of trusts are also exempt, but again, it's very fact specific. So, it's something that you'd make this transfer under the advice or the direction of an attorney. So the spousal refusal. So if you're married and you're using these spousal transfer rules in order to get one of you eligible for Medicaid, part of the plan also includes very often something called a spousal refusal. And the spousal refusal is basically a document where the spouse that is receiving the property, the spouse that's not seeking Medicaid coverage, essentially tells Medicaid, I'm refusing to make my assets and my income available for my spouse's care because I'm concerned about my own needs in the future. And this sounds mean and it sounds a little harsh, but it's really there as an asset preservation tool so that the assets and the income and the property are available for the benefit of both spouses. So the spousal refusal is a really important tool to obtain Medicaid eligibility, but the flip side of that is Medicaid reserves the right to ask the spouse for a contribution, and they also reserve the right to potentially come after either spouse's estate in the future. So very often when we are planning for one spouse, when we get the first spouse onto Medicaid, the job isn't over, because we also want to make sure that the healthy spouse has a plan in place in the event he or she needs care in the future. There are these look back periods that are imposed, and because the second spouse can't just, at the last minute transfer assets to the spouse because the first spouse is on services, we have to make sure that we're leaving enough time whenever possible for that healthy spouse to protect his or her assets as well and have a plan in place. And part of this plan includes making sure the healthy spouse, and however he or she has assets titled, that those assets don't pass to their sick spouse. Because if you've done all this planning, you got someone onto the Medicaid program, and the healthy spouse unexpectedly predeceases that individual, and they inherit money from them, it's going to impact their services and their eligibility, and it may have unanticipated consequences. So the last question, or the last topic under elder law that we'll touch upon, is how to leave assets to your heirs. So one thing I'll note is there's another session of this where we'll go into this particular topic in much more detail. So I'll just very quickly touch upon this. This was also one of the handouts that I sent out, so which has, if you want to make notes on it. But essentially the 4 ways that assets or property pass to other individuals is through intestacy, operation of law, a last will and testament, or a trust. So intestacy basically means when you die with some asset in your name alone that doesn't name a beneficiary and you don't have a will. So the laws of intestacy is a statute that's in New York State. Other states have similar statutes on the books as well. And really, intestacy is New York State determining what happens to your property at your death because you don't have a will. So kind of similar to the Family Healthcare Decisions Act, it creates a hierarchy or a list of individuals, and it also sets out what percentages those individuals share in your estate. So for example, if you are married and you have children, the New York State laws of intestacy say that your spouse will get the first $50,000 off the top, and then your spouse and your children will split the rest. So this may be what you want, you may be fine with that, but if you are someone that has minor children, you may not want them inheriting from you at a young age. If you have a child that is disabled, you may not want them inheriting outright at all because they may be getting services in the future. Or you may want to benefit someone that, a niece or a nephew or a godchild or someone else. So the laws of intestacy, take your ability to plan out of the picture. And the administrator, whoever is going to be handling your estate, also has no control over how things get distributed. It's all set by law. And that may not be reflective of what you actually want for your property. The second way assets pass to your loved ones at your death is by operation of law. Operation of law basically means that when you pass away, your assets are either have a joint owner or they name a beneficiary. So if you have a life insurance policy and it names your spouse as the beneficiary, then at your death, that life insurance policy will pass by operation of law to your spouse because your spouse is your designated or named beneficiary. If you have a joint bank account that you've opened up with one of your children, so that he or she can help you pay bills and things like that. At your death, your child will become the owner of that account. And I use that as an example because sometimes children are added to bank accounts for the purposes of convenience, and to make sure someone has access to money to pay bills and things like that. If your intention is for that individual or that child to really only be there for convenience purposes, you need to make that very clear to not only that child, but to your other beneficiary or your other children, because that's something that constantly comes up in contested estate proceedings. So something to be aware of. The third way that assets pass to loved ones is through a last will and testament. And I'm sure many of you heard this of this document, but a last will and testament is basically a document where you name someone who's going to be in charge of handling your estate. You designate your beneficiaries and in the whatever percentage you want them to receive property in. And then the last will and testament also gives you the option to do additional planning. For example, if you're concerned potentially about estate taxes, or if you're concerned about a loved one who has a disability or has financial issues, or maybe, God forbid, has a substance abuse issue, and you want to benefit them in some way, but you don't think that they can manage the property themselves, you can set up a trust for them or plan for them in your last will and testament. And then finally, we touched on this earlier with the discussion of the revocable trust, but a trust is another vehicle where you can allow property to pass at your death. So there's various types of trusts. There are supplemental needs trusts, there are revocable trusts, there are trusts that you create in your last will and testament, there are irrevocable trusts, but all of them essentially provide for what happens to property that the trust owns. So I touched on this before, but one of the main benefits of creating and funding a trust during your life is at your passing, whatever assets are titled in the name of that trust will automatically pass to the beneficiaries, which is nice because that means that there's access to resources right away without needing to wait for court, which, as I mentioned earlier, can take a number of months or even longer. And if we're talking about something like real property and there's no access to the cash in a probate proceeding, someone needs to be floating the money to pay the expenses while you wait for the authority to sell the property. So that is it. If anybody has any questions, feel free to ask them. You could also put them in the chat box. You can email me. If you have documents that you're not sure if they're okay, I'm happy if you want to send me an email with a copy of the document. I'm happy to take a look and review them for you. But other than that, I think that's basically it. Let me just check and see if there's any questions here.
Thank you.
Thank you.
Bye, ladies. Have a good night.
You
You too.
too. Take care. Bye-bye.